Hi, this is Harry. I will be presenting about two cases today. The first one, which is our primary case, is Ranch LLC versus Taco Bell Corp. In 1997, Taco Bell used a Chihuahua in one of advertisement in the US to, comp- to compete against the other fast food chains in order to fight the burger wars. The dog was made to speak through special effects. The dog's advertising catchphrase was "Yo quiero Taco Bell," which means "I want Taco Bell." In 1999, Ranch LLC, the plaintiff, sued Taco Bell Corp., the defendant, because the plaintiff was claiming that defendant had breached an implied in fact contract. An implied in fact contract is when a party requests another party to disclose an idea and understands that the other party discloses it with an expectation of compensation for the use of the idea. Here are the facts of the case. Taco Bell saw the Psycho Chihuahua at a trade show and approached Ranch LLC about using the character in retail licensing. Ranch LLC's licensing agent thought that was a great business opportunity, so they sent Taco Bell a proposal for use of the Chihuahua character. The proposal includes how much of a percentage Ranch LLC would get in return and how much they were going to charge as licensing fees. However, Taco Bell neither accepted nor rejected the proposal. At this time, Taco Bell hired a new advertising agency and asked the new agency to run with the idea of Psycho Chihuahua. The mixed up was that the Chihuahua that was aired in commercials was the Psycho Chihuahua, an idea that came originally from Ranch LLC. Even though the new agency worked on it and made new advertisements with it, the commercials were very successful, and Taco Bell continues to use the character. Ranch LLC sued Taco Bell for breach of implied in fact contract, misappropriation, conversion, and unfair competition. Taco Bell moved for summary judgment on all claims, arguing that no implied in fact contract was created, and that even if one existed, it was preempted by federal copyright law. Taco Bell also argued that the idea to use a Chihuahua came from its new advertising agency only, and that Ranch LLC's idea were not new. The issue for this case is were the artist's implied contract claims preempted under the Federal Copyright Act. So, the answer is Yes, when a party requests another party to disclose an idea and understands that the other party discloses it with an expectation of compensation for the use of the idea, an implied in fact contract is created. An implied in fact contract usually arises when a party accepts a benefit from another party for which compensation would normally be expected. When a party can show that both parties understood that compensation would be paid for services provided, a promise to pay fair value may be implied. The parties are not required to have reached an agreement on price, duration, or other terms of the contract for an implied in fact contract to exist. Defendant agrees that the parties had reached an understanding that if defendant used plaintiff's character, defendant would pay plaintiff for its use. At first, Taco Bell won. The trial court then ruled that although plaintiff had enough evidence to maintain a breach of implied in fact contract claim, that claim was preempted by the Federal Copyright Act. The court therefore granted summary judgment in favor of defendant. However, Ranch LLC appealed the grant of summary judgment, and the Sixth Circuit reversed, finding that the contract claim was not preempted by Federal Copyright Act. In 2003, plaintiff was awarded over $30 million in damages from a jury. The precedent case of Server versus Director versus Detroit Edison Company was used in the decision of Ranch LLC versus Taco Bell. Server is the employee and the plaintiff, and her employer is the defendant. Server sued her employer seeking damages for coercion and breach of contract based on the allegation that the defendant appropriated an idea, which she submitted through an employee suggestion program. This is very similar to the Taco Bell case, because although no contract was formally signed, the disclosure and use of the idea triggered the implied in fact breach of contract. The jury verdict found the defendant had willfully converted the plaintiff's idea that she had submitted under the defendant's employee suggestion plan. The jury awarded the plaintiff over $3 million in damages. In conclusion, it is very important that we protect our intellectual properties and have do not use or do not disclosure contract ready to be signed every time we present our ideas to another party. Here are two questions for discussions. The the first question is, how would you protect your idea from being stolen if it has been altered, altered or built upon? The second question is, how would things be different if there was a confidentiality contract signed when Range LLC disclosed the idea? And here's my references. Thanks for watching.